The design of the process of guided choice dispute resolution and the generation of options for the parties to explore as conceived by the guided choice neutral is an essential part of the guided choice dispute resolution process because at its core, guided choice is a different approach to mediation. In my experience, usually most mediators will launch into the same tired old spiel at the beginning of mediations that they give at all their mediations. They'll say, hey, parties, this is perhaps your last chance to maintain control over the outcome of the dispute because you may not have that in litigation or arbitration. And, judges are sometimes fond of responding to parties who are raising concerns about mediation, saying things like, well, we'll break out and we'll deal with that, but let's just keep emotions cool because, this isn't a case where people are going to go to jail, as may have been the case when I was on the bench. And with all due respect to my friends who are mediators, I think that this is kind of the lazy approach of the weak mediator who, phones it in. And is going to do a lot of the things that tend to make people think that mediation is not as valuable for resolving design and construction disputes as I believe that it really is. In contrast to the approach of the traditional mediator, the guided choice neutral, by the time of any in-person negotiation session, will have engaged in meaningful confidential discussions with the stakeholders on both sides, the principals, their counsel, and the guided choice neutral really should have more insight than anyone involved into the reasons the parties have reached an impasse in their settlement discussions, what the resistance to settlement has been thus far, and what are the likely points of resistance to settlement that people may run into in the future. And so by this point, the mediator has not just picked a mediation date, gotten people together and started in the same old tired spiel. The mediator will have suggestions for what the settlement process should look like. And that is what we mean by process design and generation of options, which is one of the essential functions of the guided choice neutral when they're running the guided choice dispute resolution process. So, what would be some examples of mediation process possibilities that would be based upon the neutral's diagnosis of potential grounds for impasse in the future and the needs of the parties? Well, a guided choice neutral has way more options than I could ever cover in a short video like this. But, one option along the lines of process design would be assuring the parties that there won't be any negotiations over things like dollars that might be exchanged until the parties' needs are satisfied regarding information that they need to put the business decision makers in a position to decide whether it's in their strategic best interest to settle at this point or whether to fight on in arbitration or litigation. Oftentimes when people say they're not ready to negotiate, what they're saying is they don't have enough information to make that sort of a decision. Another option the guided choice neutral could explore would be to set out an agreed schedule with target dates that might take care of some of the concerns of the parties. What information or, what has to be accomplished by certain deadlines in order for some of the parties to feel good about the process. It may be the case that people are reluctant to engage in a lot of evidence taking or information exchange in a mediation process rather than just doing it in arbitration or litigation. And so maybe there needs to be time constraints put around the exchange of information, or maybe even budgets for evidence taking within the guise of guided choice mediation. Perhaps even what would be the role of the parties' expert witnesses, if expert testimony or expert weigh-in is needed for complicated disputes. Certainly another important option for, designing a process that will satisfy the needs of the parties, is this cooperative information exchange, which could be done, just an exchange of some electronic information that's shy of all parties, turning out their pockets for all the electronically stored information they may possess, or it may be limited to just certain kinds of paper documents. but it could be anything. It could, be an exchange of information similar to a deposition, with or without a court reporter being present. Other options that a guided trace neutral could explore when they're thinking about process design and generation of options, is whether a non-binding evaluative opinion might be needed on certain key issues, similar to the sort of findings of fact or law that an arbitration tribunal or a judge might make, and this is one of the reasons why some parties would pick a certain kind of mediator, is they have particular respect for the mediator's knowledge and experience, sometimes judges, former judges, in terms of substantive areas. And so, what would be the most timely and cost-effective manner of getting through an issue like this? Say, for example, if you have a mechanics lien dispute and there's a disagreement between the parties about whether or not a lien claim is likely to be valid on, one particular grounds that might be the basis for a motion to dismiss. Well, some sort of a non-binding evaluative opinion could be what's needed to break through the impasse. And if that's not the sort of opinion that could be provided by the guided choice neutral, there's nothing that would stop a creative guided choice neutral who's thinking about process design and generation of options from figuring out who is out there that might be able to provide this information on a non-binding basis, on an inadmissible basis. Or, if the parties thought it was constructive and they wanted to roll the dice, it might even be the case that that evaluative person's opinion might even be admissible or might even be binding. There's no end of options that a guided choice neutral can explore when they're thinking about process design and the generation of options in creating this process that will hopefully would allow the parties to get past whatever it is that has them hung up on settlement. Another tool in the guided choice neutrals toolkit might be, perhaps a social meeting of the stakeholders, possibly even without lawyers. I could see maybe even like a social breakfast between the disputing business people before they sit down to engage in what could be, an acrimonious day of back and forth. At one point, it's likely that these parties liked each other and wanted to work together on a design or construction project. So maybe there's a spark that can be rekindled and people can have some of those social relationships, brought back to life, or at least maybe a reminder of why they liked the counterparty in the first place. This is the sort of thing that can perhaps clear the runway for a meaningful negotiation. When we think about process design and generation of options, certainly a meeting of expert witnesses within the confidentiality of mediation process can be very useful to get the experts to have a better understanding of what the other's perspective is and possibility reduce their disagreement on certain issues, and maybe help the mediator come up with what would be a path forward for them to work together constructively and to figure out, we thought we disagreed on most everything, but it turns out really it's only 2 or 3 things that we're hung up on. And the point of all this process design and the generation of options by the guided choice neutral, is to try to deal with whatever has hung the parties up in the past in their attempts to settle, and to take out whatever might be an impasse in the future. Because it's often the case that when you have a neutral or a mediator or a facilitator or whatever you want to call that person involved, there may be strong emotions or even feelings of anger between the parties, and sometimes even between their lawyers. For example, a feeling by one party that the other side is not dealing in good faith, or that maybe they've not been treated fairly or professionally, and sometimes people even feel cheated or lied to. And, when these kind of feelings are involved, these emotions are involved, the traditional shuttle diplomacy mediation, where the mediator, convenes a negotiation session too early before the parties are ready to negotiate, and essentially forces the parties to stake out these extreme opposite positions and to begin this positional negotiation on the extremes. This is generally not what is going to work to push through a situation where the parties may have these strong feelings or a lack of distrust. That kind of a mediation might be doomed from the beginning. And, I don't have any data on this, but just my experience from being involved in a lot of lousy mediations is that, this lack of proper process and bringing people together, in what is likely to be a doomed mediation is what may be responsible for a lot of people's negative feelings about mediation in the industry. And so, I think that if the parties and their counsel and the guided choice neutral can generate, new procedural options that are focused on, maintaining or strengthening key relationships, taking into account, pro-social procedural issues, that breakfast, that I was talking about, or even things that might seem trite or even silly, like, what's the right venue for people to get together and, what's the right setting, does it matter seating arrangements? What rooms are people in? Is there any, when are we going to take breaks, to try to diffuse emotions? These are the sort of things when we talk about process design and the generation of options that can be really useful for a guided choice neutral to use to set the table in a meaningful way so there can be meaningful negotiations. Now, one of the things that my mentor, Paul Lurie, has really driven home with me when we're talking about process design and option generations is, his opinion that the design of mediation should include, what he refers to as what if scenario planning, thinking about possible roadblocks that may be encountered during the negotiation, but you want to consider them before people start discussing money or settlement positions, because that's when emotions can tend to, hijack the process and lead to people acting in ways that aren't constructive. So, what are examples of what if scenario planning to be discussed before there's an impasse? It can help if the neutral asks the parties to consider, what if there's an impasse over a particular legal issue or factual issue, or maybe a damages calculation issue? What if there's an insurer that disagrees with a proposed settlement, but the insureds are in favor of it? Like, what would we do in those circumstances? Maybe let's have, without necessarily having a perfect answer, let's give a little bit of thought to what might happen if we encounter that roadblock before we encounter it with sort of the charged emotions of negotiating over dollars in actual settlement positions. Like, what if the person attending the negotiation claims that they don't have authority to change their past positions or to increase a settlement offer or something like that? What if it's true? What if it's not true? What if the project is ongoing and a delay in settlement, would lead to a delay in project completion or complications of, pursuing the project? What would we do? Asks the guided choice neutral, if we run into that roadblock in the future, what sort of constructive things might we be able to do at the time that would help us get past that? What if the parties are committed for one reason or another to have to commence litigation or to commence arbitration before the possibility of settlement through mediation is exhausted? What if there's some reason? Maybe it's a statute of limitations or, whatever. Some externality that would make people have to start litigation. What do we do if we need to go into court and file a pleading before this process is done? The guided choice neutral, as part of his or her process design and generation of options, can take parties through these scenarios and discuss these issues and, what would be acceptable outcomes if these kind of roadblocks are encountered. They can be discussed with the parties and their counsel privately before these problems surface, in order to help the parties consider how to circumvent a circumventable impasse that might otherwise terminate the mediation prematurely. So, one of the key principles of guided choice dispute resolution is process design and generation of options by the guided choice neutral, which is something that he or she will do after engaging in these meaningful, confidential discussions with the stakeholders before convening them prematurely in a negotiation session. That is the hallmark of a lot of doomed mediations, at least in my experience, that proceed along the lines of traditional design and construction mediations.